Hi and good day everyone. In today's videos, we will talk about director appointments and legal duties. Okay, so let's start with the director. So, who is director actually? So based on the Section 2 of Company Act 2016, director includes any person occupying the position of director of a corporation by whatever name is called. So it includes a person in accordance with whose directions or instruction the majority of directors or corporations are accustomed to act and an alternate or substitute director. So, in accordance with Section 210 of Company Act 2016, director includes Chief Executive Officer, Chief Financial Officer, Chief Operating Officer, or any other person primarily responsible for the management of the company. So, next we proceed to the types of director. So as we can see that there are two types of directors, which are non-executive director and executive director. So now let's see what are the difference between these two types of director. So for the non-executive director, they are non-responsible for the day-to-day management of team and don't perform daily functions within the business. They only take part in the collective decisions of the board of directors and express delegations in company. While for the executive directors, they work full-time as an employee in managing the company. They are responsible in making strategic decisions to drive the organization forward and meet overall business objectives.
Who could be a director in a company? Let's have a look at the qualifications of being a director. First, a person should be a natural person. Second, a person is at least 18 years of age. Besides, he or she is not an undischarged bankrupt. Moreover, he or she has not been convicted of a serious offense within the past 5 years relating to promotion, formation, or management of a corporation. Furthermore, he or she has not been convicted of a serious offense within the past 5 years involving battery, fraud, and dishonesty. In addition, a person has not been convicted of an offense under Section 213, 270, 218, 228, and 539 of Company Act 2016. Lastly, a person has not been disqualified by the court under Section 199 of Company Act 2016. A person is disqualified from being a director if he or she does not fulfill the qualifications above as stated under Section 198 of Company Act 2016. Under Section 196 of Company Act 2016, there's a difference in the minimum number of directors between a public company and private company. In a private company, the minimum number of resident directors can be one only, while a public company is required to have at least 2 resident directors.
So, how is a director appointed? To appoint a new director, the company secretary must be notified under Section 50F, and the company secretary will prepare forms under Section 201, Companies Act 2016, and the board resolution. The board of directors must approve the appointment of a new director by signing the board resolution. Under Section 202(1), a person named as a director in an application for incorporation of a company shall hold office as a director from the date of incorporation until that person ceases to hold office as a director. The appointment of subsequent directors is determined by the articles of the company, and they may be appointed by ordinary resolution. Once the documents and board resolution are completed, the company secretary will submit them together with the information such as the date of the appointment, the date of birth, email address, full name, nationality, residential address to the Companies Commission of Malaysia. In conclusion, a person shall not be appointed as a director of a company unless he has consented in writing to be a director and make a declaration that he is not disqualified from being appointed or holding office as a director of a company under Companies Act 2016.
According to Companies Act 2016, Section 213, Subsection 1, Director must exercise his power with proper purpose for the best interest of the company, which means that the Director must prioritize the company's interests rather than personal interests, and he cannot use the company to make secret and personal profit without approval from the company. Situation where the Director does not act for the interest of company. The Director misuses the property of company. The Director uses any information of company to make personal profit. The Director uses his position to receive personal profit. Director takes away the opportunity of company to make personal profit. Director engaged in business which is in competition with the company.
Besides, Companies Act 2016, Section 213, Subsection 2 stated that a director should exercise reasonable care, skill and diligence with the knowledge, skill and experience which may reasonably be expected of a director having the same responsibilities and any additional knowledge, skill and experience which the director in fact has. This means that a director should avoid from making negligence in performing his duty as director, which makes the company suffers loss. If the director causes a company to suffer loss, the court will judge based on the motive of the directors. A director cannot be sued for breach of duty when he simply makes a decision that causes the company to suffer loss based on Section 214 Business Judgment Rule. This includes the director A. makes the business judgment for a proper purpose and in good faith. B. He does not have a material personal interest in the subject matter of the business judgment. C. The director is informed about the subject matter of the business judgment to the extent the director reasonably believed to be appropriate under the circumstances, and the director reasonably believes that the business judgment is in the best interest of the company. However, the director still can be sued for making a business decision that causes the company to suffer loss if the director makes decision for personal interest rather than company's interest, and the director does not exercise the duty with skill, care, and due diligence. So let's have a look at the case related to director duties.
Okay, so one of the famous cases related to director duties is the case between Majlis Amanah Rakyat Mara and Dr. Abdul Rahim Al-Halim in 2018. So now let's start with the background of this case. So in this case, Mara holds 29% in Med Bhumika. In turn, Med Bhumika owns 49.5% of the shares in MBMR, while MBMR holds 22.58% interest in Perudua. So before the dispute, Med Bhumika board was made up of 7 directors, and where only 3 out of 7 directors was aligned with Mara. The majority, being 4 out of 7 directors, were aligned with the other minorities shareholders. So, on 7 March 2018, UMW issued an offer letter to Med Bhumika to purchase its 49.5% stake in MBMR for the price of RM 2.56 per share. So the next day, Med Bhumika's board held a board meeting to consider the UMW offer. So the board resolved to appoint an independent financial advisor to advise on the UMW offer. A few days later, on 12 March 2018, Mara issued a requisition notice to Med Bhumika board to convene an EGM in order for the shareholders to pass 2 ordinary resolutions. So the first was an ordinary resolution to accept the UMW offer at RM 2.56 per share. So the second was an ordinary resolution to appoint 2 additional directors to the board. So 2 weeks later, another board meeting was held on 26 March 2018. So the independent financial advisor advised the board that UMW offer was fair but not reasonable. Upon receiving the advisor evaluation, the board resolved to decline the UMW offer and to reject the requisition notice. Then, the board also resolved through a circular resolutions to appoint 2 additional directors to the board, resulting in a total of 9 directors being the maximum number of directors permitted under Met Bhumika Constitution. So, notwithstanding the rejection of requisition notice, MARA convenes a EGM pursuant to Section 313 of Company Act 2016, and both EGM resolutions were unanimously carried by the shareholders present and voting, as the shareholders resolved to accept UMW offer and to appoint the MARA and YEAN director to the board. So MARA then initiate proceedings to invalidate the board's appointments of the 2 additional directors via circular resolutions. So the board and Met Bhumika counterclaim for against, amongst the others, a declaration that the management and control of the business and affairs of Met Bhumika was within the exclusive purview of the board.
Dear media friends, good afternoon. I'm Mr. Ho, representative from Majelis Amanah Rakyat MARA. On behalf of MARA, I would like to extend a very warm welcome to the reporters and all the others watching our social media platforms. Without further ado, let's start our press conference today. Just a reminder, before I take your questions, please raise up your hand. Yeah, can go ahead.
I would like to ask you, sir, in a statement few days ago, MARA said it will file an originating summons against the 6 directors of Met Bhumika and the company to challenge the appointment of 2 new directors. What is the reason that MARA want to contest the appointment of 2 directors?
Okay, thank you for the questions. Well, obviously the appointment of the 2 directors, Datuk Muhammad Rizwan and Sharifuddin, was null and void, as they were appointed through a circular resolution and not through a properly convened board meeting. From MARA's point of view, they do not have any interest or basis to have been appointed. Furthermore, both of them have no shareholdings in Met Bhumika and have not received the consent of the shareholders representing more than 50% of the votes of Met Bhumika to be appointed as directors of Met Bhumika. Actually, in early March, MARA sought to appoint 2 directors to Met Bhumika, but the board refused to convene an extraordinary general meeting (EGM). The 2 that MARA had proposed to be appointed to the board of Met Bhumika were Muhammad Zaki Jali and Wong Fei Li. Zaki represents MARA, while Wong is a nominee of the Wong family that has more than 11.5% in Met Bhumika.
So, do you think MARA can win the lawsuit?
Yeah, of course. The law is that a director of a company shall at all times exercise his powers in accordance with Company Act 2016 for a proper purpose and in good faith in the best interest of the company. If directors exercise their powers for some ulterior purpose or if exercise were carried out in an improper manner, such an exercise of powers could be set aside. So I think that does conclude today's conference. We thank you for your participation and have a great day.
Dato' Abdullah, do you have any comments on your case?
I totally don't agree with what the plaintiff has just said. Now I've provided the counterclaim to the originating summons. I saw a declaration that the management and control of the business and affairs of the company was within the exclusive control of the board. Therefore, we, the board of directors, had the right to reject the UMW offer. Even the EGM's ordinary resolution could not interfere with that decision. In addition, I've also appointed our company secretary to circulate a director's circular resolution. Through the DCR, I saw a declaration to confirm the valid appointment of the 2 directors. The truth will be revealed in the court as justice will always prevail.
Breaking news, breaking news. We are now outside the High Court of Malaysia. The case of Mara and Dato Abdullah is still ongoing. Let's see what the decision will be at 2 p.m. Stay tuned with us at MGM News.
After considering the evidence found, I have allowed the originating summons that was filed by the plaintiff and substantially dismissed the counterclaim filed by the Mek Bhumika Mara Sendirian Berhad. I order cost of 20,000 ringgit to Mara payable by the first to 6 defendants jointly and severally, and cost of 10,000 ringgit each to the 8 defendants and the 9 defendants to be paid by the Mek Bhumika. Here are the reasons for my decision. First, I found that the 4 directors were in breach of their duties when the 4 directors rejected the requisition notice at the board meeting on 26 March 2018. The minutes of the board meeting show how the chairman of the meeting had wrongly referred to the requirement of special resolution instead of just special notice. Second, it was obvious that the real or predominant reason for the 4 directors to appoint the 2 additional directors was to prevent Mara from appointing their choice of 2 additional directors at the EGM. The 4 directors has not shown why there was such a need to appoint 2 additional directors in the juncture. That did not show why the appointment could not be tabled at a physical directors meeting. Third, I dismiss the argument that shareholders were not entitled in law to appoint directors at the general meeting. The board power to appoint additional directors did not exclude the company's inherent power in a general meeting to appoint directors. Section 202 of the Company Act 2016 was also referred to. The directors did not act in good faith and for proper purpose when appointing the 2 additional directors. Hence, the appointment under the DCR was invalid.
In my view, I agree with the judgment because the shareholders of the company have the right to make recommendation to the management of the company as according to Section 195 of Companies Act 2016. Besides, the board should also appoint the director for a reasonable reason and in good faith in the best interest of the company according to Section 213, subsection 1. If the requirement did not fulfill, it will be considered as breach of duties of directors.
So for my opinion, in this case, I agree with the judgment because I think that shareholders of a company needs to ensure that the prescribed requirements under Section 195/3 of the Company Act 2016 are satisfied before they can make binding recommendations to the company's board of directors. Besides that, the director of the company must make sure that all their actions pursuant to the binding recommendations are performed in the best interest or in good faith of the company.
In my opinion, to make any significant decision relating to the business, including the appointment of a new director by the board of directors, it is important to determine whether the action is acted in good faith in the best interest and for a proper purpose as a whole. The appointment should also provide a credible explanation to support the action. Or if it will violate law, just as in this case, it was obviously done by way of Director's Circular Resolution (DCR) in order to get around the requirement for a representative of Mara to be present to constitute a quorum at the directors' meeting.
From my point of view, I foresee that the shareholders' right of management review may increasingly be utilized. Directors must be aware that ordinary resolutions can make recommendations to the board to take a certain course of action. If it is an ordinary resolution, the recommendation is not binding, but it is still part of the director's duty to consider the recommendation and then decide why the directors will take a certain course of action. The rationale should then be accurately and thoroughly captured in the minutes of the board meeting. This allows for transparency and for directors to defend their decision. Lastly, it is important that both the directors and shareholders of Malaysian Companies Act, according to the responsibilities of their duties, in order to avoid breaching the company law and committing criminal offences.
In my opinions, documents are crucial. Minutes of board meeting reveal the state of mind and discussion that went on. It is important that the minutes capture what was being discussed. In this case, the minutes serve as the evidence to show the breach of director duties. Besides, directors must be mindful of their responsibilities. They must consistently act and make judgment in the company's best interest. Hence, the act of rejecting the requisition notice and the act of appointing additional directors will all have to be breaches of their director's duties. That's all about our videos. Thank you for watching.